Welcome to ABIEdu Academy's comprehensive guide to employment law. Today, we provide a complete overview designed specifically for analysts. For analysts, understanding employment law isn't just about compliance, it's a strategic advantage. It allows you to mitigate legal risks, ensure organizational fairness, and protect the company's most valuable asset, its people. Hello, I'm David. In this lesson, we'll navigate the complex framework governing the relationship between employers and employees. We'll cover foundational concepts, core federal statutes, and the emerging trends like AI and remote work that are reshaping our legal landscape today. Let's dive in. We begin with foundational concepts. The employment at will doctrine allows termination for any legal reason, while the distinction between independent contractors and employees determines eligibility for benefits and overtime, a critical area for classification audits. Misclassification is a high-risk area. As analysts, you must understand that the Department of Labor uses the economic reality test to determine control. Master-servant laws further dictate that employers are responsible for employee actions performed within the scope of employment. The Fair Labor Standards Act, or FLSA, establishes the federal minimum wage and mandates overtime pay of 1.5 times the regular rate for non-exempt employees working over 40 hours. Precision in job classification here is vital to avoid costly litigation. The DOL administers over 180 federal laws. For us at ABIEdu Academy, the focus is often on wage and hour regulation. Remember, mislabeling an employee as exempt just to avoid overtime pay is one of the most frequent sources of legal disputes in the corporate world. Next, we look at the EEOC, the body enforcing anti-discrimination laws. Title VII prohibits bias based on race, religion, or sex, while the ADA requires reasonable accommodations. The Equal Pay Act ensures that men and women receive equal pay for equal work. Fairness is the goal. Beyond Title VII, the Age Discrimination in Employment Act protects workers over 40. As analysts, ensuring these standards are met across all hiring and promotion cycles is essential for a healthy, inclusive organizational culture. Safety and support are also codified. OSHA mandates a hazard-free workplace, while the FMLA provides 12 weeks of unpaid job-protected leave. Additionally, the WARN Act requires 60 days' notice for mass layoffs, a critical timeline for organizational planning. Compliance is your strongest tool. Whether it's managing workplace safety under OSHA or navigating the complexities of the WARN Act during restructuring, your ability to synthesize these requirements into a coherent strategy is what makes you an invaluable partner. Finally, we must monitor emerging trends. The gig economy is redefining worker status, while remote work creates new jurisdictional challenges for tax and labor standards. Even AI-driven hiring tools are now under scrutiny for potential algorithmic bias. Employment law is dynamic, not static. By mastering these pillars from FLSA audits to AI ethics, you transition from a compliance officer to a strategic partner who safeguards our academy's future. Thank you for joining me today. Let's recap. Prioritize worker classification, ensure equitable pay and safety standards, and stay ahead of gig economy and AI trends. You are now equipped to lead with compliance.